The Eighth Circuit Court of Appeals has issued a ruling that could further gut the Voting Rights Act by allowing only the federal government rather than individuals, private citizens, or civil rights groups to sue under a key section of the law. So the appellate court, according to Politico, ruled that there is no private right of action for Section 2 of the law, which prohibits voting practices that discriminate on the basis of race. That, in practice, would severely limit the scope of the protections under Section 2. So on paper, those protections are themselves completely unchanged by the ruling. Like the language hasn't changed, everything's the same. It's just that the interpretation of this Court of Appeals has changed the meaning of what the law actually allows for. So for decades, it's important to keep in mind, put this all in context. For decades, private parties, including civil rights groups, and individual voters and political parties have actually brought Section 2 challenges on things like redistricting, so gerrymandering, or voter ID requirements, right? This is a way for people to challenge changes in election laws on a state level. Now, after reviewing the text, history, and structure of the Voting Rights Act, the district court concluded that private parties cannot enforce Section 2, the judges wrote. The enforcement power belongs solely to the Attorney General of the United States. So this means that a decision to bar private challenges to the Voting Rights Act would reverse decades of legal practice. It also means that outside groups have repeatedly brought successful Section 2 challenges and litigate alleged violations of the law far more frequently than the federal government does. And if this interpretation stands, then it will erase all of that. Moving forward, this practice will no longer be allowed by private citizens or civil rights groups or other organizations. Only the federal government can bring forth these challenges to election laws. Cenk.
So I'm going to introduce Nuance to this in a second. But first, the first part is easy. So why is this conservative court doing this? Because they don't want the NAACP and private individuals bringing forth cases because there'll be a lot more cases. And there's a second reason why. They know that the federal government, if it's run by a Republican president, won't accept any challenges. You can do anything you like. You can redistrict so that the black folks have no representation in any of these states. And a Republican president like Trump's gonna be like, great, why would I want less seats? I want more seats. Who cares about racism? That's hilarious. I mean, have you heard anything Donald Trump is saying? He doesn't mind racism one bit. So this court goes, oh great, when we're in charge, we'll get to be as racist as we like. So yes, so that's the terrible part, the obvious part. So Voting Rights Act is being destroyed right in front of our eyes. And it was one of the great landmarks of American politics that we were able to protect minorities through laws like the Voting Rights Act. So where's the nuance come in? Look, I hate the gerrymandering in the states. And so some of these districts get gerrymandered, so they're black districts and white districts and left-leaning districts and right-leaning districts, and the politicians are in essence picking their voters,
right,
instead of the voters picking their politicians.
It's an effort to basically dilute certain demographics of voters to help a particular party get an edge in elections, and both parties do it for sure. I do think it's important to remember that there's a recent case out of Alabama in which gerrymandering in an effort to dilute the black vote was challenged. And so this interpretation of Section 2 in the Voting Rights Act would not allow for this type of case to be brought forth and this gerrymandering to be challenged. The Supreme Court sided this summer with a group of civil rights groups and individual voters who argued that Alabama's congressional maps likely violated the Voting Rights Act, which led to the court-ordered creation of an additional majority black district next year. Thomas pointedly noted in his dissent in that case that the court had not addressed the private right of action question. By the way, this Eighth Circuit Court of Appeals decision is very likely going to be challenged all the way to the Supreme Court. We know that there are at least 2 Supreme Court justices who have a similar interpretation. Neil Gorsuch is one, and clearly Justice Thomas is the other.
Yeah, and I want you to understand how gerrymandering works. What they do is they stuff all the Democratic voters into a small number of districts so that the Republicans in the red states, so the Republicans can win more seats. But now in order to do that, the Republicans have a smaller percentage buffer for them to win. And they take, for example, in South Carolina, and take as many black voters as they can and put it in a Jim Clyburn seat. And a lot of the elite black Democratic politicians betray their own people, and Jim Clyburn is the #1 example of that. And he worked, and this is reported out recently, he worked with Republicans secretly in his own state to make sure that blacks had less representation, as long as his seat was more safe. Because he's like, oh, you're gonna give me all the black voters, so there's not 2 black districts, there's only 1? But my seat's gonna be safer and I'm gonna have more power? I'd love to work with you racist Republicans, I'd love that. That's who Jim Clyburn is. That's how a lot of these elite politicians in DC are like, oh, I am the right skin color, I am the right identity, so you should vote for me and you should support me, you're not allowed to criticize me. Yeah, what did you do for black voters though? Who cares that you're black? What did you do for black voters? And what you did was you betrayed them if you're Jim Clyburn. And so that's among the 100 reasons why I hate gerrymandering. And I'm not alone, 90% of Americans, both Republican voters and Democratic voters, hate gerrymandering. Because what they do is they take all choice away from us. So the reality is that these districts should not be based on race or which politician it favors. It should be done in a neutral way so that everyone is represented. But we don't live in that world. Instead, it's going to get gerrymandered. And now, thanks to this decision, it's going to be further gerrymandered in a racist direction to wipe out even more black voting districts.
So we'll see how this plays out. Like I said, while at this current moment, it's unclear what the next plan of action is for those challenging the 8th Circuit Court's interpretation of the Voting Rights Act. It is likely going to be challenged all the way up to the Supreme Court. And look, to be frank, I was pleasantly surprised at how the United States Supreme Court, as conservative as it is, ruled in regard to the racist gerrymandering that took place in Alabama. So I think it would be a mistake to just automatically predict that they are going to agree with what the 8th Circuit Court of Appeals is saying here, how they've ruled. We'll see how it plays out. But if they do agree with the 8th Circuit Court of Appeals, it will mean that the Voting Rights Act, which was already previously gutted by the Supreme Court, will be further dismantled. And it'll be more difficult for civil rights groups and private individuals to challenge election laws in various states. One
last thing, right wing all of a sudden loves activist judges. So when it's activists in their direction, they're like, oh yeah, you're gonna come up with a new precedent that didn't exist before?
Can we just, let's be frank about something, okay? All right, everyone loves activist judges, everyone. Okay, you just don't like it when the activist judges aren't on your side. Let's just keep it real, Cenk. We all know it. You know it, I know it, the American people know it.
I've been perfectly consistent about it my whole life.
Right.
But you're not wrong, everyone else, the minute it's an activist judge in their direction, whether it's on the issue of abortion or the issue of money in politics, all of a sudden, they flip positions instantly. Yeah. I've never flipped positions on it. Judges are supposed to interpret the law, not write it out of whole cloth. They just keep writing laws. And the #1 benefactor, guys, isn't the right wing or the left wing, it's corporations. This is what the whole point of my book is, Justice is Coming. They took over the Supreme Court and allowed for nonstop corporate bribery and rule in America. And they literally said in the memo that created that, we want activist judges in order to take over the Supreme Court and hand it over to the Chamber of Commerce. That's how we're all getting screwed.
Thanks for watching. If you become a member, you get to watch all this ad-free, except for, of course, this ad. Still, hit the join button below.